Hello everybody. Today here with us we have Professor Chinmay, who is our faculty for legal theory for the semester 2, and we also have Professor Rahela with us, who is a faculty for law of contracts in semester 2. So today we have our professor here to talk about legal realism in the courts of India. So Professor Chinmay, first could you please throw some light on what is legal theory?
So, legal theory is one of the subjects that you'll study in a law school. So, along with doctrinal subjects such as constitutional law, criminal law, tort law, it's also important to take a step back and look at the foundational principles behind all of these different doctrinal subjects. What are certain common areas, common theories which really govern these different laws? So, it looks at the nature, foundational principles, and helps to gain conceptual clarity on these different areas of law.
So I'll be very honest, at first even I found legal theory to be very abstract, just like Fosh, and I was like, why are we studying this subject? But after a court visit to Mumbai High Court and Bombay High Court, I could see why it is important. So Professor Rahela, if you could just mention why did you take us to the court and what happened?
So I organized a tour for the students of both the batches to visit the Bombay High Court because I'm very invested in them understanding not only the court, not only the law through the letter of the law, but the court through its structuring and how that really impacts how you access justice and how you look at justice. So I gave them a brief about the architecture, the dress code, the entire part, and then I took them to the court, and I think it was a really fantastic experience. The students were really happy, and they also got to look at the court in a different way from how you otherwise see and perceive the courts.
I mean, I would agree with that because visiting court in the first year of law school is very important because you understand what is actually going on there. We have been studying subjects like law of torts, law of contracts, and when you actually see law of contracts, people holding the bare act of law of contracts and arguing their case there, it's very important to see how they do it and why they do it. So we had the opportunity to hear cases, and we heard the case about some Mumbai bombing, and we heard how the lawyers not only cited bare acts but also the aspects of legal theory like natural justice and different theories like positivism and this. And we also had the opportunity to see some great legal stalwarts actually arguing the case. So I think I would thank Rahela ma'am for taking us for the court visit because it was important. So Professor Chinmay, could you please elaborate on some key concepts of legal theory, for example, from legal realism?
Right. So what you mentioned, I think one of the ways in which legal theory can help make sense of different aspects of the court visit as well, and then can connect back to different subjects that you're studying, be it contract law or constitutional law, is the idea of legal realism. It's one of the theoretical schools of thought along with positivism, natural law, and different other philosophies that we explore here. Now, legal realism, if I can characterize it, I think it's a practitioner's legal theory. It's something that emphasizes law in practice rather than law in books. So there are different perspectives of legal realism. There is a Scandinavian perspective and there is an American legal realist perspective. We chose to focus on American legal perspective, where we explored Justice Holmes, Levelin, and thinkers such as Jerome Frank. Now, there are a couple of key ideas that these thinkers articulate. One of which can relate to your experience, is about rule skepticism. There is also an element of fact skepticism. What these themes highlight is the idea of indeterminacy, of ambiguity, both in terms of how a rule is interpreted and how a fact is interpreted. Although typically one tends to assume that there are this fixed formal set of processes and there's no deviation and discretion possible. In reality, each judge will interpret a particular rule based on his or her own perceptions, biases, prejudices, so with a witness, so with other stakeholders involved in that process. So both in terms of rules and in terms of facts, it turns out that things are pretty ambiguous, and each particular case can interpret those facts and rules based on those circumstances. So what you study in books may be consistent, formal, predictable, but what actually happens in practice, as you mentioned, a senior lawyer, they will have a different sort of effect on the judge compared to, let's say, a junior lawyer. And these facts must be taken into account if you want to predict a legal outcome better. So that's really the crux of legal realism.
So like you mentioned about fact skepticism and how Jerome Frank's theory about fact skepticism is built in the legal realism perspective, we also heard a case about murder, and where the judges were trying to determine what were the real facts about the murder, what was the murder weapon and how did it happen, when did it happen. So I think even the judges in our Bombay High Court, they go very deep and they try to deliberate on each and minute points and they try to understand what it is. So I think in that aspect, legal realism is very important, and in that sense, even legal theory is very important when you try to argue your case. I would say that because we had our moot courts in first semester, we were not as intimidated as normal people, a new person to visiting a high court would be, because we knew the theatre of the court. We were made aware about it when we had our law of tort moot court in the first semester. So I think even that helped. So Rahela ma'am, if I could ask you, what is one key takeaway, one suggestion you could give to the new incoming batch on what they should prepare for and what they should look forward to, what would that be?
So before I give the suggestion, one last thing I wanted to add is that the students also got the opportunity to visit the central courtroom of the Bombay High Court, and that's where Tilak's trial was held. And it's a courtroom saturated with history, and it has so much of this conflicting, like what we have just discussed, this idea about history as is remembered and memorized by the court, and what is the current situation, and how when you retell history in a particular way, it changes your perception, and how that kind of courtroom has become a contested space in the Bombay High Court. So coming from there, my suggestion to all of you incoming students would be, wherever your hometown is, wherever you are, please go visit the court that you have at your hometown. It can be a high court, it can be a district court, a sessions court, civil court, any court. Go visit it, look at it like a sociologist, in the sense that look at it like a regular person walking into court, what that feels, what it means, make a note, draw a sketch, do anything. And then when you come to law school, and when we introduced that idea to you about the theatre of the court, aspects, architecture, you can then connect it back to the court that you've seen in your hometown. You'll also visit the Bombay High Court, and then you can kind of make those comparisons. So please go into the courts in your hometown and then come to law school.
I would agree with that, because now I can say confidently that I can visit any courtroom in court session. I can just go and sit there and observe the meeting without being hesitant enough that should I, can I. So Professor Chinmay, could you please tell us about how our course of legal theory is different, and why should actually law students study legal theory?
Right. Well, I mean, one way in which one can understand the importance of legal theory, although it may not be very apparent in the first instance, I would like to quote Justice Holmes here, when he says, life of law has not been one of logic, but of experience. So multiple examples, for instance, when Professor Rahela discussed about the Tilak trial, what do we understand by law? What do we understand by the legitimacy of that trial? All of these questions become very interesting and very relevant in contemporary climate as well. So one thing that we've been deliberately trying to do in this course at BITS Law is trying to really rethink how legal theory can be taught. So couple of things that we've introduced to that end would be decolonial perspective. So how do we make legal theory more relevant? And also, how can our students, based on their experiences, which are very localized and vernacular, how can they connect with legal theory better? So we've attempted to introduce certain Indian thinkers and introduce their legal philosophical perspectives. We've tapped into not only the Western legal theory, but sometimes Chinese legal theory and other sort of Sinocentric legal theory. So we've tried to make it plural, and we've tried to make it as interesting and relevant for students as possible. And I hope students are enjoying that.
So in the end, I would say that legal theory may seem abstract in the beginning, the courts might seem intimidating in the beginning, the judges might look intimidating in the beginning, but in this journey of 5 years, I think it all makes sense in the end, and finally when you come out, you become a better person, better lawyer, and a better thinker in the end. Thank you, Professor, for joining us, and thank you.